This is Bloomberg Law with June Grasso from Bloomberg Radio.
From where I'm standing, I could see him through the window, and then he just kind of turned to my right, and then he fired about 10 to 15 shots. Well, when we heard the shots, we kind of all just dropped to the floor and flung ourselves into a corner.
16-year-old Lila Sayarath had been sitting next to Colt Gray in math class just before the shooting that killed 2 teachers and 2 students and injured 9 others. The shooting at Georgia's Appalachia High School is the 23rd school shooting this year and the deadliest.
In essence, you are charged with 4 counts of felony murder, as outlined in the state warrants that have been issued against you.
14-year-old Colt Gray has been charged with 4 counts of murder. His father is also being prosecuted for the shootings. Colin Gray has been charged with 4 counts of involuntary manslaughter, 2 counts of felony murder, and 8 counts of cruelty to children. Barrow County District Attorney Brad Smith says there's no broader meaning in bringing charges against the father.
I'm not trying to send a message. I'm just trying to use the tools in my arsenal to prosecute people for the crimes they commit.
Joining me is Ekow Yankah, a professor at the University of Michigan Law School. They charged the father right away. Do you think the speed is because there was sort of a precedent already set in the case against the parents in the Michigan school shooting?
You're right to notice the speed at which they charged the father. It is one of the things that shows that we're entering into a new legal world. As you point out, the Ethan Crumley case in Michigan, where the parents were convicted, was considered precedent-setting and path-breaking, but it doesn't take long for a case that was seen as utterly novel to be in a prosecutor's back pocket and result in charges in, just hours in the next set of egregious, horrible cases. But it shows you that what was, completely novel becomes a ready-made tool for the next case. I don't know if they charge him so quickly because of some facts they found during the case, something he said during the interview. And of course, the other feature of the Crumley case to keep in mind is that the parents of Ethan Crumley were on the run in Detroit for quite some time before the police found them. So perhaps prosecutors had the flight risk in mind. But you're absolutely right. We're in a little bit of a new world when this is something prosecutors think of as a quite ready-made tool.
Prosecutors charged the father with 4 counts of involuntary manslaughter, 2 counts of felony murder, and 8 counts of cruelty to children. The prosecutor said the felony murder charges were connected to the child cruelty charges. But don't murder charges against the father seem like a stretch?
I do think you're right that these are charges that see yet another step forward in holding parents accountable, to hold that they're directly responsible. Involuntary manslaughter is typically related to somebody's recklessness or negligence that caused these deaths. But second-degree murder is a stronger claim that, in some sense, you killed somebody even without premeditation. As you know, Georgia's murder laws are somewhat idiosyncratic, and so those second-degree murder charges look to be attached to the idea that his son killed 2 children, and thus the cruelty charge to children is a second-degree murder. But as a general position, it stands for prosecutors being even more aggressive in saying that this father didn't just recklessly lead to this death, but that his actions in some serious way caused these deaths.
For involuntary manslaughter, what has to be proven?
So typically involuntary manslaughter is attached to either recklessness or more commonly negligence. So recklessness is the idea that you knew there was a risk of something terrible happening, a substantial and unjustified risk, and you ignored it. And that often grounds manslaughter. In some states, there can be an involuntary manslaughter. Negligence is the idea that you should have known that there was something, a substantial or unjustified risk. And typically, that's what grounds involuntary manslaughter.
In May of 2023, the father and son were interviewed in connection with threats to carry out a school shooting, but authorities didn't arrest the teenager then because they couldn't connect him to this online account. And at some point after that interaction, Gray bought his son an AR-15 style rifle. Do you think that that's going to be the main thrust of the prosecution? You know, you were warned in this conversation.
Yeah, it sounds like, much like the cases we've seen that came before, it's these sort of horrible and gut-wrenching facts. The facts that give you a feeling as though a parent not only ignored a child who was crying out for mental health help, not only ignored a child who is fascinated with violence and school shootings in particular, but instead of steering this child away from these kinds of things or securing your weapons, you have parents in both cases, but in particular in this great case, who not only metaphorically, but quite literally put the gun in the child's hands, goes and buys them a weapon and arms them. And it's those kind of egregious facts that lead prosecutors to eventually seek direct responsibility. Now, I'll say in many parts of the country, one of the reasons we really care about trying people in front of juries is that different communities will have very different relationships to these moments. So there are just lots of communities where a father buying a gun and taking their son hunting seems like a perfectly ordinary part of the communal experience. And in other communities, this is close to unthinkable. And so I don't think the facts are without anything for a defense lawyer to point out. But when you have a child who's so troubled, who's so fascinated with violence, it's not surprising that we all are outraged when a father, instead of making sure guns are away, arms the child with essentially a rifle that's made for war.
And during that interaction with authorities, the father, Colin Gray, told the investigators that he was teaching his son about firearms and safety and how to hunt, and that if he found out that his son was the one involved in that online threat, he would basically safeguard the guns. Is that something the defense might point to, especially in a state like Georgia where there's a lot of hunting?
No, absolutely. And look, I mean, I teach cases where courts come to very different decisions because there are very different communal norms on what counts as negligence with a gun. You know, one of the cases is a Georgia case where the judge says, in Georgia, we have a long and proud history of hunting. You know, I grew up in a community where there were very different feelings about guns, but, you know, with some families for whom one of the proud moments was when the children went on the first hunting experience with dad. So different communities are going to feel differently. You know, the dad tweeted out something like it was one of his happiest moments or proudest moments when his son finally shot a deer. That being said, when you know that your son is this troubled or this fascinated with violence, you know, every parent knows when a child says, well, I didn't do it. It's one thing for prosecutors to not be in a position to say, I can prove something beyond a reasonable doubt. It's quite another thing for a parent to just take at face value a child saying, Dad, it wasn't me. When we have reason to worry, it can lead to this kind of utterly tragic result.
In the Crumbly case, there was a lot of evidence that the parents ignored their son's deteriorating mental health. In the case of Colt Gray, there also seems to have been contact between the family and the school about his mental health, but the facts are very unclear at this point. Doesn't it get tricky when a case involves a parent's knowledge of their child's mental health struggles and how they address that?
Yeah, I mean, look, one of the things that's hard about these cases is, though this particular case is so devastating in its result, we all feel it's obvious what should have happened. It's also true that, you know, lots of kids go through lots of troubled periods, and many parents try their best. And I struggle with how to answer this myself. Look, even among trained psychiatrists, they will tell you that it's very hard to predict when a patient is actually going to resort to violence, when there's a gap between fixation, fascination, mental health issues, and actual action. And so I think there are a lot of parents out there who are going to worry that they'll be held responsible for what their troubled child does. That being said, you know, part of what drives these cases is that there are particularly egregious facts. So, for example, when this mother took him in seeking mental health help, apparently, and we're all finding out the facts, but her note said something like, he should have been in therapy for months now. He deeply needs help. And so it's those facts on the ground that parents themselves did see or could have seen this coming. Indeed, the latest reporting shows that when he texted her, she immediately called the school because she was afraid that he was going to resort to violence. So it is absolutely true that parents worry that they can't always see the future. But in some cases, when they did, it's going to be much harder to deny the prosecution's indictment that you could have prevented this.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with University of Michigan Law School professor Ekow Yankah. We'll talk about new information that the mother of 14-year-old Colt Gray called the Georgia high school about 30 minutes before the shooting to warn the staff of an extreme emergency involving her son. I'm June Grasso, and you're listening to Bloomberg. For the second time, a parent is being prosecuted for a school shooting by his child. The shooting at Georgia's Appalachia High School last week is the 23rd school shooting this year and the deadliest. 2 students and 2 teachers were killed and 9 others were injured. 14-year-old Colt Gray has been charged with 4 counts of felony murder, and his father, Colin Gray, has been charged with 4 counts of involuntary manslaughter, 2 counts of second-degree felony murder, and 8 counts of cruelty to children. I've been talking to Ekow Yankah, a professor at the University of Michigan Law School. You followed the Crumbley case in Michigan where both parents were found guilty of 4 counts of involuntary manslaughter. Did the parents have more warning signs about their son in that case?
That's one of the things we're all waiting to find out. And, you mentioned earlier that this father was arrested quite quickly. So I think one of the things that we're going to see developed at trial is not only what was the reported incident beforehand where he posted about school shootings, how much was he fascinated with school shootings, how much did parents have reason to know about his fixation with violence, and frankly, what kinds of things did they discover in their investigation or in their interview with him that would lead to such quick charges. And so, alongside the rest of the country, I'll be waiting to find out exactly who knew what when. What did he say?
And now you mentioned the mother called the school to warn them about her son. Apparently the conversation was 10 minutes and about a half hour before the shooting. I'm wondering if a possible defense will be, the school didn't act quickly enough.
Yeah, I don't think that'll be much of a defense for him at his criminal trial, especially because he's not the one who acted. From what the reporting is now, it seems like a horrible set of missed opportunities. A school counselor went to see if he was there, mistaken him for another child with a similar name, and took a backpack of the wrong child. So it's all these sort of horrible missed moments after missed moments that lead to the death of 4 people. I do think the real question will be whether or not those moments play into further civil liability for the school. As you know, in the Oxford shooting in Michigan, the Oxford school system was eventually not found liable for any negligence on their part criminally. But that doesn't settle the question of whether or not those individual parents and injured people will think that the school missed its own duties to protect them.
What I found odd, the prosecutor declined to say if the father had any gun locks or other mechanisms to secure the firearms inside the home. But Georgia has no law requiring safe storage.
Look, I would say one of the things about these cases is that all of us who are either criminal law practitioners or teachers are fascinated with how the law is going to respond, how criminal law is going to respond to this question of whether or not you're liable for somebody else's action. But for those of us, when we're thinking of ourselves as citizens and parents, the question should be much less abstract. The question is not whether or not this particular father is liable. I care about that insofar as I care about the way criminal law works. But as a parent, if we care about protecting our children, it's clear to me that what needs to happen is the way we treat our society that's saturated in guns. What do we think about gun regulation? What do we think about red flag laws? And what do we think about safe storage laws? In Michigan, it was only after the Crumbley shooting that we passed the first set of gun regulations, including safe storage laws, in 4 decades. So as heartbreaking as this particular case is, and whatever one thinks about what should happen to this father, it seems to me a kind of hopeless mission to think that we're going to solve this never-ending social problem of school shootings by prosecuting one parent at a time.
Critics say it's a misguided effort to make parents the scapegoats while lawmakers fail to pass legislation to reduce gun violence. The lawyer representing Jennifer Crumbley on her appeal said it's shifting blame onto parents in the absence of states passing legislation.
I think that's right. I mean, look, I think in some sense these are not the exact same question. I am cautious about the way in which we treat every social problem as though it's a criminal law problem, but I don't pretend to have an easy answer about whether or not parents who are so grossly negligent or so reckless should be held liable. You know, it goes against a long-standing criminal law principle that you're not responsible, barring a very few exceptions for accomplice liability or felony murder. That the principle that I taught just last week to my criminal law students in their first week is that you're not responsible for the actions of others. But yes, extraordinary cases are going to push that intuition. The real point is exactly what you said. Setting that aside, whether or not you think this parent should be culpable, it's obvious to me this is not how we're going to solve the problem. And if legislatures are going to think that we have our anger sated by essentially, blaming one parent at a time or bringing the hammer down on one parent at a time, locking up a parent here, a parent there, while forever telling us that we'll think about gun regulation in some other time, then we're going to keep visiting these tragedies.
Many people thought that the Michigan case would be an example and would make parents more aware, but apparently not.
I mean, look, criminal law will never solve all our problems. And I tend to think we overly use the criminal law, but it's not that it has no role. Criminal law can have a sanctioning effect. It can have some deterrence effect. Maybe somewhere there are some parents who are more careful than they were beforehand. But if we want to solve the underlying problem, we should do the best we can with our regulatory law. If we want people to lock up their guns, what we should do is simply require them to lock up their guns. Even if that's not a perfect solution, it surely beats trying to prosecute one parent at a time.
Now, I want to turn to the son for a moment because he's 14. He's being charged as an adult. Mm-hmm. I often wonder what's the point of the juvenile justice system when teenagers are almost always charged as adults when there's a murder or, a similar really serious crime.
Yeah, you're absolutely right. We have long decided that we don't truly believe in the juvenile part of our juvenile justice system. That is to say, our essential nationwide stand is that you'll be tried as a juvenile just so long as the crime isn't important enough that we want to try you as an adult, which is a weird way to relate to the juvenile justice system. If the point is when you're young, there is a certain way in which you're not fully responsible, then that's true for serious crimes as well. But overall, it is a symptom of that which we've been discussing. It's a symptom of us constantly aiming our criminal law at every social problem.
And being charged as an adult rather than a juvenile is a game changer, isn't it? It changes everything from the process to the prison time.
It's just a whole different ballgame, right? It means potential sentence after sentence after sentence. Now, in this case, as the judge reminded him, he's not eligible because he's a juvenile for the death penalty. But almost everything else is on the table, almost everything else. Look, I mean, what he did was just devastating. But, when I see 14-year-olds playing, I just think there's so many things they do that are so obviously irrational. There's a real question. Do we really think they're children and thus not fully responsible? Or do we just mean something like, as long as we're not sufficiently angry, we'll pretend you're a kid? We throw it out the window when it's angry-making enough.
Yeah, the prosecutors here decided right away that they were going to try him as an adult, perhaps fearing the backlash if he's convicted and not sentenced to a long time in prison. The prosecutor also said that he wasn't trying to send out a message by charging the father. I would hope that prosecutors would use every tool in their arsenal to hold people accountable for crimes that they commit. Is that believable that he's not trying to send out a message?
The one way in which I'm sympathetic is prosecutors are people too, and they live in these communities, and they are heartbroken and devastated when these things happen as well. And so I believe that when a prosecutor looks at something like this, they are, like all of us, outraged and think, I want to hold somebody accountable. But no, ultimately, of course, part of what prosecutors do is use the law as a tool for sending a message to what they believe is unacceptable behavior, what they believe their community wants to hold as a line of accountability, and even what they think matters for their own views of the law and even their own ambitions for the law and their own careers. So I don't think he's necessarily cynical or lying, but it's too much to believe that a prosecutor wouldn't think that this kind of immediately nationwide visible case wouldn't send a message.
Any final thoughts, Ekow?
One last thing, and I thought about this a lot during the Crumley case. Again, I understand why a prosecutor would want to hold parents like this accountable. If I'm perfectly honest, I'm a parent. I don't know what I would do if I were a prosecutor in this position, whether or not I would also want to press charges. But I do think we shouldn't be so cavalier about what it means to hold parents accountable for the behavior of their children. And in particular, as we saw with one precedent affecting a sister state, what it will mean when the next case is not as dramatic or not as exceptional and not as egregious, and prosecutors still use these tools to prosecute a case. And what people should really realize is that often when prosecutors do this, it's not nearly so much in the public eye. The overwhelming majority of our cases, something like 95%, are plea bargains. And those cases never attract the kind of attention that these sensational cases do. And so every time we empower prosecutors to threaten people with further criminal liability, we're also giving them the power to exact a huge number of guilty pleas that will never see a jury or a reporter.
Thanks so much for being on the show. That's Professor Ekow Yankah of the University of Michigan Law School. Coming up next, conservative Supreme Court justices are less likely to explain their recusals. I'm June Grasso, and you're listening to Bloomberg. There's been a lot of scrutiny on the Supreme Court justices recusing themselves, or rather, failing to recuse themselves. Last term, Justices Clarence Thomas and Samuel Alito were criticized for failing to recuse themselves from the controversial presidential immunity case, despite calls to recuse because of Thomas's wife's support for the push to overturn the election results, and because flags flown at Alito's homes allegedly suggested sympathy for those efforts. And now a review by Bloomberg Law shows that the conservative justices, unlike their liberal colleagues, routinely decline to explain why they recuse themselves from cases. Joining me is Bloomberg Law Supreme Court reporter Kimberly Strawbridge Robinson, who's looked at the numbers. So, Kimberly, tell us about the difference between the conservative justices and the liberal justices when it comes to explaining their recusals.
Yeah, so I think it really goes back to a lot of the ethics scandals that have been in the news a lot, and sort of the pressure that the public had on the Supreme Court to issue a binding code of conduct. I think people were surprised to learn that the Supreme Court was not subject to sort of binding rules like other federal judges. And so last year, in November of 2023, the justices, they issued a code of conduct, but they were clear that these are rules that are not new, that they're ones that they've been following. But since then, we've been seeing, this distinction between liberal justices and conservative justices, where presumably everybody's following the rules, but the liberal justices will explain the reasons why they're recusing from cases, whereas none of the conservative justices have. And so, these are really short explanations, maybe a sentence that just sort of says something general like previous work experience. But, it is really a stark line between the democratically appointed justices and the Republican appointed justices.
Once the Supreme Court has taken a case and it's going to oral argument, you don't often see a recusal then. When do you usually see the most recusals?
You're right. And so there's only one case for next term so far where there's a justice recused. Those are few and far between because of the problems of, possibly having an evenly split court so that the court can't actually decide the question that it agreed to decide. But most of the recusals, the vast majority of them, come whenever the parties ask the justices to hear the case. Typically, when they deny those requests, they have thousands every year, they deny most of them. And that's where we see the overwhelming majority of recusals come in.
Are most of the recusals because of prior work experience of the justices? For example, Elena Kagan worked on the case when she was a Solicitor General.
So most of them are for their previous work experience. I think you mentioned Justice Kagan. It's really remarkable that, she's been on the court so long now and she's still having recused from cases where she was a Solicitor General just because, it's almost every litigation that was involving the federal government that she sort of needs to sit it out. So, she's sort of an outlier there. But a lot of the other justices who were, appellate court judges, we see them from time to time having to recuse. And then, it becomes less so as they sit on the bench for longer and longer. And so that's, a majority of the recusals. But particularly when it comes to Justice Alito, he has a lot of recusals because he's one of the only justices to own individual stock. And so we'll see him, occasionally recused because he owns stock. And interestingly, we also see him when he's recused, if the justices do decide to take up the case, he sometimes sells his stock so that he can then come back on the case.
Reporters and court insiders can sort of figure out most of the time why a justice is recusing, right?
Yeah, with a little digging, some of the commentary that the justices have given about recusals is that, it's obvious why a justice is recusing. And I guess to them and, the insiders who are familiar with all their stock holdings and, where they sat on courts previous to the Supreme Court, it can be somewhat obvious, but it does oftentimes take some digging. Particularly, there was a case last term where Justice Thomas recused himself and, he didn't provide an explanation, but it was involving one of his former clerks. And so, that's something that an insider might find obvious, but, any member of the public who doesn't watch these things as carefully wouldn't really know. So that's where the explanations come in handy.
The conflict with a former job or stock, it's pretty obvious, but there's this catch-all that requires a justice to disqualify if their impartiality might reasonably be questioned.
Yeah, and this is where it gets sticky, and I don't think it's really unique to judges or lawyers, but whenever we're asked to sort of, gauge how biased we might be, we have a pretty bad measure for that, and the rules are not very clear, and it's up to each individual justice to decide, whether this hypothetical reasonable person who knows all of the facts might think that they are biased and should recuse themselves. But it is really where the tricky ones come up, and I think where some of these explanations would be most helpful.
Also, when they refuse to recuse themselves, you don't know why either.
That's right. And actually people I talked to, some watchdog groups said that it actually might be more useful or more public interest for justices to explain when they decide not to recuse. We have seen, a few times, very few and far between, over the decades where a justice has explained their recusal, but typically that or their reasons for not recusing. Justice Scalia famously did so in a case involving then Vice President Dick Cheney. But again, those are very rare. And, some people that I talked to said that there's some danger with providing really robust explanations like that.
Will you explain that? Because in the statement with the Ethics Code about recusals, it said, explanations can be ill-advised in certain instances. Examples include circumstances that might encourage strategic behavior by lawyers who may seek to prompt recusals in future cases.
Sure. Well, I think, from speaking to ethics experts, I think what they're trying to get out there is this idea that if one justice recuses because they have this particular relationship with someone, then it sort of provides a precedent for all the other justices, whether or not they agree that recusal is required there. And they're sort of held to that standard, even though recusal decisions are supposed to be made by the individual justices themselves. And so there's sort of a danger with setting a precedent that not everybody agrees with. And, the chance that a lawyer who's acting zealously for their client will seek to use that recusal decision to sort of get a leg up in the case, to get a particular justice, whether it be conservative or liberal, kicked off the case to give their clients a better shot at a good outcome.
Are recusals increasing?
We haven't seen a big difference in the number of recusals. I mean, again, prior work is going to provide a big bulk of them. There's really very little that the justices can do. The one where there's a potential for it to go down would be in stocks. But again, most of the justices don't own individual stocks. It's really mostly Justice Alito. But, overall, the numbers haven't really been affected. It's still really early since the Supreme Court adopted its code of conduct. But, people I talked to said that's not surprising, because the justices emphasized that they've always been doing this. They've always been following these rules for recusals. They just put it down on paper so that people knew that they were bound by something and not sort of going out there willy-nilly and making these decisions without any sort of standard.
Do you know which justice has recused the least and which the most?
Well, Justice Thomas seems to be the one who has recused the least. I think that makes a lot of sense, though, based on some of the stuff we're talking about here. He doesn't own any private stock that would require him to disqualify himself, and it's been a really long time since he was a judge, so a lot of those cases just aren't in the federal system anymore. So Justice Thomas really does recuse a lot less frequently than some of the other justices, but also Chief Justice Roberts doesn't recuse a lot either. A lot of his cases seem to work their way through the courts, and really where we see him getting recused the most is people will name him as a party in the case, and then obviously you shouldn't hear that case.
And what about the justices who have the most recusals?
We talk a little bit about Justice Kagan. She has a lot because of sort of the realities of her job that she touched almost every case that ran through the federal system for the time that she was the Solicitor General, and those cases last a long time. And then when we really see it sort of a bit, as I mentioned before, where it'll sort of peter out the longer that the justices are on the court. So right now, you have a lot of recusals from the newer justices, Justice Jackson and Barrett and Kavanaugh and Gorsuch, and not as many from the ones who have been there a long time. But over time, those will also sort of tend to peter out.
Chief Justice Roberts, when the Alito flag flap was going on, said, it's up to the individual justices to recuse themselves. That's a decision they make. But you, in your story, said there are some state Supreme Courts that have different mechanisms for recusal.
Right, and not only different mechanisms for all of their judges, but also for the judges that sit on the highest courts in their states, so are sort of similarly situated to U.S. Supreme Court justices. And there are a handful of states that do different things, and Texas was one of the ones that was brought up a lot to me. You can refer the decision to the full court so that you can get everybody else's perspective on it. And one thing that I think watchdog groups were saying was that, maybe that isn't a good fit for the U.S. Supreme Court, but it's not something that they should just dismiss out of hand. They should at least look into it and see what the dangers are, see what the experience has been like in those other states.
The legislation and the Democrats who want binding ethics codes, is it because, as far as recusals, they want more transparency, or is there another reason?
I think it's in large part because of the transparency. I think particularly when it comes to things like providing explanations, just making it a little bit easier for the public to know. But, I also think it has a lot to do with sort of bringing back public confidence in the court. The Supreme Court has had historically low public confidence numbers as of late, and that's really a big deal for the Supreme Court, which famously doesn't have a way to enforce any of its judgments except through sort of the goodwill of the people. So I think a lot of people see it as a good step to sort of getting some more goodwill with the public.
And it's been quite a few years now that we've been saying this year is historically low approval. It just keeps going down. So we'll see.
It does. And we'll see if the adoption of the Code of Conduct does anything to increase that public confidence, and sort of what the justices decide to do themselves that might increase it. There have been a number of justices recently, particularly as they're going around promoting their books, who have talked about this and who have said that they think an enforceable code would be desirable. So I guess we'll wait and see what happens next.
Thanks so much, Kimberly. Always a pleasure to have you on. That's Bloomberg Law Supreme Court reporter Kimberly Strawbridge Robinson. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.